Welcome once again to our continuing YouTube video series on business law. My name is Christopher Neufeld of Neufeld Legal, and in this particular YouTube video we will be discussing what a contract is. Now, to go to its most basic elements, a contract by definition is an agreement between two or more parties that is enforceable at law. And to understand that, we have to look at the requisite elements for a contract to be valid. And those 5 requisite elements are 1, offer and acceptance, 2, consideration, 3, capacity, 4, consent, and 5, lawful purpose. Now let's dig into each of these elements in turn. Offer and acceptance and consideration. For every lawful, valid contract, you need offer, acceptance, and consideration. So firstly, we have the offer. The offer is made from one party to another party, or more than one party, that contains all the important and relevant terms of the contract. Secondly, the other party must agree or accept the offer. And third, with the offer having been accepted, something of value, whether it's an item, money, or a service, is exchanged between those parties involved in the contract so as to constitute the requisite consideration. Furthermore, the contract to be valid must be such that each of the parties to the contract have the ability or capacity to understand the terms and the nature of the contract. And thereafter, each of the parties involved in the contract must also freely consent or agree to those terms in the agreement. And finally, for the contract to be valid, it must be negotiated and brought forth for a lawful purpose or objective, such that there is no violation of law that's going to be effectuated by the terms of the contract being carried out. Now, if we look at the 4 types of contracts, we have some general distinctions between various contracts. There can be an express contract, where it is a legal agreement in which the terms of the contract are transparent and known to all the parties involved. Conversely, there might be an implied contract. In an implied contract, the terms of the contract are inferred by the parties' conduct and actions, such that one can apply what the contractual arrangement is and what the terms of that contract are. So going back to our elements of a contract, we look at the offer and acceptance element. And the individual that initiates the offer or makes the offer is the party that's known as the offeror, whereas the party that is accepting the offer or is intended to accept the offer is known as the offeree. So you have those two parties, and for the contract offer to be valid, the offer must include a serious intent on the part of the offeror. Furthermore, the offer must contain definite terms or specifications or details. Some terms may be clearly defined, while others are implied. When it comes to a corporation, company, or business, and it is encouraging the purchase of a product or service through advertising, this is considered to be an invitation to treat. Thus, a contract occurs when the product or service has actually been purchased. So what transpires then is there is a communication on the part of the offeror of the offer to the intended target or offeree. The communication can be in a multiplicity of forms, but it is not a successful offer until it is actually received by the offeree. Meanwhile, an offer can be terminated or effectively canceled for a variety of reasons. Among those reasons would be the occurrence of a lapse, where the offer is not accepted within a specified or reasonable period of time, such the offer comes to an end. More determinative, an offer might be revoked by the offeror or canceled by the offeror prior to its acceptance by the offeree. Meanwhile, with respect to acceptance, the offeree has a responsibility to have clearly communicated its acceptance of the proposed agreement. Once again, it can communicate in many different forms unless specified in the offer as to the requisite form of communication. Nevertheless, it must be clearly communicated, and it must also be known that the communication has been properly received by the offeror for the acceptance to have transpired. Certain acceptances must be fulfilled within a specified time limit where stated. Otherwise, the offer might well expire or be canceled. Also, the offer must follow the original terms of the offer when it is accepted. To amend or alter the terms set out in the offer is to constitute a new offer or counteroffer, such that it does not reflect acceptance but the presentation of a new offer, thereby vacating the original offer and replacing it with the counteroffer, where such that the offeree now becomes the offeror to the new offer, and the offeror originally becomes the offeree, and it is up to that original party that initiated to now accept or reject the counter proposal. Otherwise, there is no agreement and no contract. Going on to the subsequent element of consideration, where an offer is accepted, the courts technically require that something of value must be exchanged as between the parties who are involved in the contract. The actual value or amount of what is being exchanged between these two parties, legally called the consideration, is not really a determinative factor. Simply the fact that there is a value that is being exchanged, such that it can clarify and communicate the fact that there is consideration. Hence, one may see oftentimes in written contracts the transference of a mere $1 or $5 together with the other legal terminology that is antecedent to that aspect. But it is the conference of that $1 or $5 or $10 within a major contract that creates the binding element for purposes of the court. Moving on to the next element, which is that of capacity. When we're talking of capacity, we're talking about the parties, the offeror and offeree, having the requisite legal capacity to understand what they are agreeing to in the form of the contract. And what the court is looking for is that the individuals are not under any disability or lack of capacity, which can be denoted by a developmental disability of one of the parties. One of the parties having impaired judgment. Oftentimes this can be due to age or mental infirmity, but also lacking the requisite age of majority, such that the courts may determine that the lack of their age is reflective of their lack of capacity. So for purposes of a minor, they might invalidate a contract unless the contract is necessary to ensure that minor's health and welfare, such as an employment contract. If a contract is not considered to be in the minor's best interests, the court can well declare the contract void. Similarly, if an individual party to the contract is under developmental disability or is lacking in judgment, operating under impaired judgment, there also the court may well determine that the contract is void. Moving on to the element of consent. Each of the parties to the contract must freely consent or agree to the agreement that is being sought. Each of the parties must understand what they are contracting themselves to, understand the terms. And there are situations where consent might be precluded. Such situations include misrepresentation, mistake, undue influence, and duress. So what is misrepresentation? Well, misrepresentation is where there's a false statement about a material fact that is found within the contract, and it is so important to the contract that it causes the other person or party to enter the contract, and such that they would not have potentially entered into the contract but for that misrepresentation, or at least on the terms that are specified therein. And misrepresentation makes genuine consent impossible. So there are a number of different scenarios where there might be misrepresentation. There might be innocent misrepresentation, where a person incorrectly believes something to be true. There might be fraudulent misrepresentation, where one party tries to deceive the other for an illicit purpose. Subject to the circumstances, subject to the law, misrepresentation could well allow a buyer or offeree to subsequently back out of a contract that they had initially entered into. Another scenario is mistake. And mistake can cause a contract to be deemed unenforceable by law. And there are various types of mistake. One could have a common mistake. And this kind of mistake occurs where there is an error made by both parties in the contract. There might well be a unilateral mistake, where one party to the contract made a mistake and the other party knew of that mistake but did not attempt to correct it. Finally, there can be a clerical mistake, which is an error done by a clerk or a store employee involving numbers and having incorrect pricing. Depending on the circumstances, mistakes can void or make contracts voidable, but it is highly dependent on the circumstances and by the prevailing law and the implications thereof. Now we move on to undue influence and duress. An undue influence is a situation where one party applies pressure on another party to form a contract. They become increasingly aggressive. They put pressure, and that creates the undue influence. Similarly, there can be duress, where one party is subject to threats or violence or intimidation to effectuate their entering into the contract. In both these instances, consent is lacking as seen by the law, and thus the contract may well be declared void. As always, one needs to look towards the underlying circumstances and their impact on the arrangement to clearly determine what the impact of undue influence and duress might well be to the contract. Finally, we look at the aspect of lawful purpose. And the idea behind lawful purpose is that there is no illegality associated with the contract. Does the contract, if carried out, portend to facilitate some transgression of criminal law, provincial law, municipal bylaws, or other impropriety that the courts and the law would consider there not being a lawful purpose or lawful objective behind that contract, such that the court would deem it inappropriate and effectively void out the contract unless there is some special rule or dispensation that enables the parties by act of law, by act of government, to enter into that contract in the face of what might otherwise be considered an unlawful objective or purpose. So once the contract is formed, how is a contract discharged or brought to an end? Well, that can occur in a number of different ways. One such way is through performance of the contract. The parties complete and perform what has been agreed to, and by its fulfillment, the contract is completed and is thus brought to an end. Alternatively, the contract might not be completed or might be of an indefinite term or for an extensive term, and somewhere prior to that, the parties might mutually agree to bring the contractual arrangement to its end, and their mutual agreement, whether this requires writing or not, can be brought to an end at that point. Next, there is a scenario of impossibility, where the frustration of the contract makes it impossible for the contract to be fulfilled. We have seen this recently with the COVID-19 pandemic, where the government has shut down for a period of time certain business arrangements and certain abilities of individuals to perform their functions in business. This impossibility thereby precludes the fulfillment of many contracts, and it was neither fault of either of the parties to the contract, such that the contract has been made impossible and the contract is effectively brought to an end. Finally, there is breach of contract, where one or the other party has failed to perform its obligations as stated in the contract. And in failing to perform, the contract is in breach. So when the breach comes about, it effectively brings the contract to an end, or effectively cancels it, although the party that is the non-breaching party may choose to allow the contractual arrangement to continue, even in the face of this breach. But should there be a breach and the party that is adversely impacted by the other party's breach. That party may seek legal remedies to respond to the breach that has been perpetrated, because the performance of the contract will not be completed, and that party that is adversely affected might take appropriate action thereupon. So what that adversely impacted party may do is it may seek an award of damages as compensation for the breach of the contract. This may include liquidated damages, representing a sum of money specified in the contract to accord for the breach, or the breach might be resolved by arbitration or by the courts at trial. An alternative remedy is specific performance, wherein the adversely impacted party looks to the court to order the breaching party to fulfill some or all of the terms of the contract to correct the situation that has been perpetuated by the breach. Conversely, the adversely impacted party might seek some type of injunctive relief, which precludes the breaching party from undertaking a specific action, which was otherwise negatively impact the party injured by the breach. The breaching party may also be subject to a privity of contract, such that the adversely impacted party, through a lawsuit, seeks to prove the contractual relationship with the party that breached the contract, and seeks to take action specific to the contract or force out arrangements coming from the contract so as to protect their interests. Another remedy that the adversely impacted party may seek is rescission, wherein that party goes to the court and seeks the court's imposition of an order that the contract be canceled and whatever has been provided by the non-breaching party to the breaching party be returned and restitution created in some form. Naturally, as in all circumstances, much of this is going to be highly specific on the particular circumstances underlying the contract, the arrangement, and the breach of that contract. And as such, much is going to be dependent on the factual specifics. Now, this provides some basic substance to what is involved in a contract. We trust it has provided some edification, clarification as to that role. For more specific contractual matters of a legal nature, please do not hesitate to contact ourselves, as our law practice is heavily focused on contractual matters and business matters. We have the information provided in this YouTube video, and we hope you've looked to our other YouTube videos for more information pertaining to aspects of contracts and business. Thank you.